Okay. Really pleased to start this next panel, and we have a terrific lineup. I'll let Adam introduce our various speakers, all old friends and one new friend. Kate is Kate Briscoe. She asked me, went to have little photos of people, and she said she didn't have one available, but I could substitute a movie star. I did have Scarlett Johansson up there, but I decided not to. There'd be too much, look like a deep fake. So I want to introduce our moderator, who is a very old friend. Adam, for crimes he did not commit, had been my executive officer when I was on active duty. We went all over the world, including to some sort of scary places from time to time.
Sharks and cows.
Sharks and cows. Yeah, we walked in a barn one time and I was freaking out. But no, Adam he's recently retired after a 24-year career as a judge advocate. He's now a professor at the National Defense University at National War College, specifically, where he had been a distinguished graduate of the National War College, which is interesting because when you go to War College, you're competing against every career field. And for a judge advocate to be a distinguished graduate, it's not that hard. No, no, it's quite an achievement. And Adam did everything during his active duty career. He was a staff judge advocate. He deployed twice for year-long tours in the Middle East. He was the senior lawyer in the Combined Air Operations Center, where you have to make instantaneous decisions where somebody's going to live and or somebody's going to die, depending on what that decision is. A really terrific background. Now, one of the things when Adam retired to become a civilian professor at National War College in the strategy area, he didn't have the opportunity to have a retirement ceremony. So right now, I hope that you will join me in congratulating Adam on a fantastic 24-year career. And as a special treat, tomorrow you will see the better half of that at the Oler family when Kate is down here, and she's going to give a lecture on ethics. But for now, I'm really looking forward to this panel on hot topics. And thank you so much, panelists. And Adam, it's all yours.
Thanks, General Dunlap. And we had a conversation this morning. He, for me, will always be General Dunlap. I'll also say when you retire, one of the toughest things is figuring out how to dress yourself. So if you're wondering if I'm wearing the exact same thing in my LinkedIn photo, the answer is yes. Right down to the tie. So with that, okay, maybe in a couple of years I can help with that, but for now, rely on your family at first for dressing stuff. So what I want to do is we're going to do very, very brief introductions. The webpage has great detail on what the speaker's extensive background is. We also, when we planned this, wanted to make sure we had plenty of time for your questions. And this is a hot topic, potpourri approach, but our goal here this morning is to introduce you to the really, really exciting, very, very broad range of national security law matters that some of you may want to follow up on, be interested in, pursue, make careers in, et cetera, et cetera. And I think one of the things that's most impressive that is if you were sitting here 24 years ago or 15 years ago or even 10 years ago at this conference, how much the technology and everything related to it has changed recently, which also suggests that it's going to change a lot in the future. But General Dunlap put together the panel, and we'll start with that. It's my privilege to introduce a new friend of mine, Ms. Kate Briscoe. She's the Chief of National Security Law Section at Homeland Security, at the Homeland Security Law Division at DHS ICE. She has a long and extensive experience with that organization. She's going to speak to us today about new developments in counterterrorism, immigration, and law enforcement, and in the law enforcement arena. I do want to emphasize, though, but because she's not active duty, because she's active civilian, but because of her role, she can't talk about specific cases per se, but she can certainly give us a good introduction to what she's tackling and some of the really amazing issues that she's dealing with. So hand it over to you, ma'am.
Great, thank you. Immigration law and national security are deeply intertwined. I came to realize that when I came out of private practice, where I'd been doing civil litigation and criminal defense, and I'd defended an individual charged with material support to a terrorist organization, and defended somebody charged under the Espionage Act. And so as I was looking to move into public service, I thought, well, this is a natural fit. I really thought these were fascinating issues. I'd like to handle them from the other side. And so I joined ICE into the National Security Law section. And it was eye-opening how much national security work is done in the immigration arena. And I will say, and I'm going to talk about this a little bit more later, but ICE is not just immigration, it's also customs enforcement, and that's a huge part of ICE. And for the national security cases, we use the authorities granted to ICE agents as customs officers and immigration officers, and they have the full panoply of criminal law enforcement authorities. So I describe my Homeland Security investigation agents as the FBI on steroids, because they have extra powers and authorities that the FBI doesn't have, which is why we work so well with the FBI as a team in the counterterrorism cases. So I am going to focus my remarks on counterterrorism, and I'm going to give you kind of a little bit of a higher level intro to immigration law, trying to boil this down into a way that makes my comments about casework relevant without burying you in the weeds of immigration law, because the statute and regulations is about that thick, and it's equally complicated. So at a very high level, when we're looking at the counterterrorism cases, again, that's just a subpart of national security in general, I like to describe the analogy of a house. You have an individual who lives 3 streets over and is calling and saying, can they come over for a visit? That's the analogy of visa security program, and where you're looking at who is this, what do we know about them, what's their intent in coming here. You have the neighbor who shows up at your door and knocks on the door, right? That's an individual presenting at a port of entry. And then the question is, what's the purpose of their visit? What do we know about them? And so that's a different analysis. And that's one that's usually done by Customs and Border Protection, because they're the ones who man the ports of entry. Then you have the people who are inside the United States, right? They're already in the house. And they could be in the house in a lot of different capacities. They could have entered legally, for example, on a visa. They're here completely in compliance with their visa. Okay, there you are. They could have entered on a visa, say, and overstayed the visa, so now they're out of status. They could have entered without any papers, and so they have no status at all. So we look at kind of the national security and counterterrorism world and what we know, and we call derogatory information, at all of these different points. So I'm going to talk more about the people who are already inside the United States, and 2 kind of types of cases that we're increasingly seeing that are significant to us. One is the universe of individuals who have been convicted of a terrorism-related crime and are finishing or have finished their criminal sentence in BOP custody. They, if they are not United States citizens, will then be looking at immigration removal proceedings. And that is an extensive process of multi-layers of due process. Let's say a Al-Qaeda convicted terrorist has served what would be under the material support to terrorism statute, a 20-year statutory max. So maybe he was associated with Al-Qaeda around the time of the 9/11 attacks, 17 and a half years ago? He's coming out of Bureau of Prisons custody. What are we going to do with him? Are they just going to let him go and walk around the U.S., convicted terrorist? I don't think so. So then we start looking at, as I mentioned, using the immigration authorities. And ICE would take custody of the individual from the Bureau of Prisons, initiate removal proceedings. They would go in front of an immigration judge, have appeal rights to the Board of Immigration Appeals, be able to seek relief in the U.S. Circuit Court of Appeals, and potentially up to the Supreme Court. So convicted terrorist, that's going to be an easy charge for us under the Immigration and Nationality Act because it contains removal charges based on terrorism. The question then is going to become, does the individual get relief under the UN Convention Against Torture? Because we can't remove anybody to a country where it's more likely than not that they're going to get tortured. So that's a big question. You know, I don't think it would be hyperbolic to say that Osama bin Laden, had he not served a life sentence, would have probably gotten deferral of removal under the Convention Against Torture. We would be concerned with what a country that was willing to accept him, what its intentions might be. So, so assuming there isn't protection granted, now we're looking at, and a final order of removal, all due process is done. We need to execute the final order of removal, and that would be the repatriation process. A lot of countries don't take their nationals back. They'll say, yep, our citizen not going to issue you a travel document. So that is a dance that we do with foreign governments all the time. We're like, you have to take your national back. No, we don't like to do that. And they, you know, especially they'll be like, no, this is a national security case in the counterterrorism sense, but particularly like child predators and stuff like that. Like, no, we don't want that back. You need to take your person back. So that's an ongoing dance, and you know, after a certain amount of time, if we haven't been able to repatriate a national, we have to release them. So that is a kind of constant challenge for us about what to do with convicted terrorists from countries where we can't return them, and we are doing our best to come up with ways to potentially find third countries to take them, or any other way we can resolve the issue. But that's definitely a pressing issue now, particularly as a number of kind of Al-Qaeda-related folks are coming out of BOP custody. And with all of the ISIS prosecutions, we're going to be dealing with this in 10 more years with the ISIS prosecutions. So that's one of the big areas I wanted to highlight for you. The other area are cases where we don't have a criminal prosecution and we might not go criminal. And so I highlight this area because it really emphasizes ICE, and I'm focusing mostly on HSI, Homeland Security Investigations, their role as customs officers and immigration officers. So HSI participates on the FBI's Joint Terrorism Task Force, and in fact, after the FBI, they're the largest provider of resources. And what they bring, as I kind of mentioned before, are these extra authorities. So as a case is unfolding, it may be for many different reasons that the strategic decision is to go and use administrative authorities rather than criminal authorities. Maybe, hypothetically, there's classified information, there's some sort of source network. You don't necessarily want to, you know, let on to everything that we know, and yet the person has overstayed their visa. Well, that's a removal charge, and that's a charge which could give us authority to detain the person. So if we thought they were an imminent threat, we could use those authorities. Now, it'll be challenged in court, right? We have to go in front of a judge and say, well, the person's detained, but this is why, and here are the legal authorities, and here's the evidence we can point to. But it is a very valuable tool, particularly in this environment where threats pop up really fast, and they, go from not even being on the radar to like, we got to do something. So having the ability to leverage some of the immigration laws can be an important tool. And that is an area that we do a lot of work in. So those were my high-level observations about the immigration process, and I look forward to any questions later.
Great. And like I said, we've left plenty of time for questions on the other side, so if you note them down, and we'll go from there. It's now my privilege to introduce Zhanna Malekos-Smith. As you can see, she's a Reuben Everett Scholar here at Duke University. She's a former judge advocate as well. Looking at her bio, one of the most interesting things is that she is matriculating at King's College in the United Kingdom. And from the strategy practitioner world, that is basically as good as it gets. Some of the most important work in strategy over the past generations been done at that university, and that's just terrific that she's there. And she's going to speak to us now about the latest developments on the conflicts in cyberspace and employing gray zone tactics in cyber operations. So, Zhanna, over to you.
Thank you. Good morning. It's an honor to be here today on this panel and to speak with you all. So I've been asked to offer some general remarks on gray zone tactics in cyber operations. And what I mean by gray zone is this category of activity that falls below the threshold of conventional war. And I've structured my remarks to focus on the political dimensions of this as well as the legal dimensions. So to help frame our discussion today, I would like to share with you a quote by the great U.S. Supreme Court Justice Oliver Wendell Holmes Jr., who wrote that the right to swing my fist ends where the other man's nose begins. Now, apart from sounding like a code of conduct for an 18th century gentleman's fight club, I would submit to you that this is actually a very useful lens for looking at conflict in cyberspace. So when a state swings its fist in cyberspace and it collides with another state's nose, what does that look like? And more importantly, what legal rights are triggered as a result? Now, taking the first legal aspect of this, currently there is no standard international legal definition of what constitutes a cyber attack. And the closest that we've come in developing a conventional understanding of this was in 2013 with the development of a treatise called the Talon Manual. And that was written by a group of governmental experts who proposed under Rule 30 that a cyber attack is a cyber operation, whether offensive or defensive, that is reasonably expected to cause death or injury to persons or damage and destruction to objects. So let's take apart that definition. What we have here is harm to human life and also physical kinetic harm. But what about harm to data? How does that come into this analysis? And this has been a common critique levied against the Talon Manual's definition. Other theorists have advocated for less of a preoccupation with direct physical effects and a broadening of the definition to include harm to data and data systems. Specifically, Professor Matthew Waxman at Columbia Law School has offered this definition of a cyber attack. It should include an effort to alter, disrupt, destroy computer systems or networks or information or programs on them. Now, to present to you the other side of the debate, other theorists have stepped in and said, time out here. The problem isn't that we don't have some uniform legal definition of what a cyber attack is. The real issue is that we don't have a general consensus on what bad conduct in cyberspace really needs to be stopped. So I take the time to highlight to you these competing perspectives to underscore the point that the policy and the law in this area is still very much undergoing development. So what bad conduct does rise to the level of a cyber armed attack, a computer network attack that yields violent effects, physical violence? And some classical examples offered by Harold Koh, who is the former legal advisor for the US State Department. In 2012, he proposed these. 1, operations that trigger a nuclear power plant meltdown. 2, operations that open a dam above a populated area, causing destruction. And 3, operations that disable air traffic control, resulting in plane crashes. And again, a common theme you'll notice from these 3 examples of a use of force is that they all reference some form of kinetic physical effects. But what about harm to data? And that is an open question still. So to go back to the quote at the beginning by Justice Holmes, what happens when a state's cyber punch doesn't amount to a use of force? And although I am no Rod Serling, I would submit to you, we've entered into a 5th dimension, an amorphous realm between peace and war. In short, next stop ahead, the Twilight Zone. So I reference the fantastic science fiction series, Rod Serling series, because it's an excellent teaching device for framing how these nuances and gray zone tactics apply. I mean, here the analogy fits so well as being this amorphous realm between peace and war, the 5th dimension. Here, cyberspace is the 5th dimension of war fighting. So moving from there, imagine, if you will, we have an act in cyberspace that doesn't amount to an act of force. There are no physical kinetic effects. However, it's more than just a low-level intrusion, for example, defacing a government website or doxing a celebrity. So it's this middle ground between the two that still packs a punch. So let's talk a little bit about gray zone tactics here. Now, in 2015, then the U.S. Army Special Operations Commander Joseph Attell testified before the House Armed Services Committee, saying that actors leverage gray tactics as part of a large strategy campaign seeking to secure their objectives while minimizing the scope and scale of actual fighting. So here, it's a type of activity that's strategically calibrated to not exceed the de minimis damage threshold under Article 51, think death, damage, high-level destruction, but it's still dealing a blow to your adversary. Now, some case examples. In 2014, with North Korea's intrusion into the networks of Sony Pictures Entertainment. And on that example, the 2015 Department of Defense's Cyber Strategy Report references the Sony hack as an example of the political utility of cyber operations. And this case demonstrates how cyber operations can present revisionist actors with an attractive opportunity to undermine a state's values, in that example, it being free speech. And you can cause that effect on a massive scale with a relatively low risk of retribution. Another more recent example was in 2016 with Russia's involvement in leaking the emails from the U.S. Democratic National Committee and the information operations targeting the integrity of the presidential election. So to build granularity, let's look at some common tactics. Now, there are 3 different types of nonviolent political cyber attacks, and these were developed by Professor Thomas Rid at Johns Hopkins University. So if you're taking notes, here's the first one. Sabotage operations. Now, these are operations that are highly targeted, focusing on affecting your adversary's system and technology. Think it's targeting the machinery. There's no harm to the human operator. However, the harm is constrained to financial harm to that entity being targeted and also reputational harm as well. A quick case example was in 2012 when Iran unleashed the Shamoon virus, targeting Saudi Aramco, which is one of the world's leading suppliers of crude oil. And in this particular attack, it harmed the hard disks of 30,000 computers, resulting in great financial harm to Saudi Aramco. Now contrast that with the second type. We have subversion operations, where the target isn't a machine, it's the human mind. And here, the goal is to erode the social beliefs and values of that society, to target and undermine the collective trust in their social institutions. Last but not least, we have espionage operations, and this comes in 2 different flavors. You have national security motivated espionage, and then commercially motivated economic espionage. Speaking to the latter, what that is stealing a state's trade secrets and proprietary information to then confer an economic advantage to your home state. Now, as a matter of public policy, the United States does not engage in commercially motivated economic espionage. However, other states, such as China and Russia, do engage in this type. So what's the future of Twilight Zone conflicts? Well, actors that employ gray tactics here need not technologically be successful in actually infiltrating the adversary's systems. Rather, the sheer ramifications of the act in and of itself are enough to deal a psychological blow to your opponent, to garner that international spotlight for your cause, to further your revisionist ambitions. Going forward, a significant challenge for the United States and other states is how to develop counter tactics to this type of activity, which is not new to the pages of history by any means, but this medium presents new challenges in how it propagates and amplifies those effects. And what we've seen so far, the United States' approach is to levy economic sanctions against bad actors, also exploring issuing legal indictments and other diplomatic efforts. Other recent developments, we have U.S. Cyber Command being stood up as its own unified combatant command, and in 2018, the Department of Defense released a new cyber strategy report rolling out the concept of Defend Forward, and it defined that as being acts to disrupt malicious cyber activity at its source. So that could be interpreted as a signal that the Trump administration's approach to this type of disruptive cyber activity will take a more aggressive stance, defending forward to disrupt it. So to leave you on a more uplifting note on this subject, I would like to close with a quote by the Roman historian Livy, whose observation still holds true centuries later, and that is, just as there are laws of war, there are laws of peace as well. So when a state swings its fist in cyberspace and it collides with another state's nose, it will still be held accountable for its actions by the international community. And although it follows its own discretion in abiding by these principles, the eyes of future generations will still be upon it. So I thank you for your time, and I look forward to your questions.
Thank you. So we'll now turn to Colonel Dawn Zoldi, who's with the Office of the General Counsel at the U.S. Air Force Academy, and specifically she runs the business practices section at the university, which is a fancy way of saying she does everything at the Air Force Academy. She was the staff judge advocate at the Air Force Academy previously, and Dawn is also one of the country's top experts in domestic drone operations. I made the mistake for my own career of following Dawn in her last assignment in the operational world, where she had been the Chief of Operations Law at Air Combat Command. And I come in there, and there are just stacks of information, and people are calling from very high up in SC levels saying, okay, what's going on with this domestic drone operation, et cetera, et cetera. And finally, my boss calls me down and says, Adam, do you know anything about drones at all? And I said, well, I know I just bought one for $30 at the airport, but that's about it. So Dawn, it's a privilege to have you here. You're going to talk about some of the newest legal issues with domestic drones, maybe talk a little bit about the distinction between domestic drone operations and why it's so different from what a lot of us saw overseas, and why what we brought back from overseas may not be relevant to domestic operations. So
thank you very much, Adam. Thank you. So I'm going to do a little bit of audience participation here. If you think you're just going to sit there and listen, you're wrong. So my first question to you is, when you think of drones, what are the three major issues that come to mind from a kind of a legal and policy perspective? Domestically. Domestically. Let's not talk about targeted killings. Air traffic, so safety. I heard safety. Privacy. Property crimes. Counter UAS, so I'm going to say security. Okay. So those three topics of safety, privacy, and security are the three things that I'm going to talk about today. And I'm going to talk about them in the context of the 2018 FAA Reauthorization Act, because amazingly, this act, which was passed in October of 2018, actually addresses all three of these for the first time. And I'm going to foot stomp that as we go along. So here's my second question to the group. Is anybody a drone aficionado in the audience? No hands. Okay. Does anybody know the three different kinds of drones or how they categorize drones in the FAA? Okay, so they call them unmanned aircraft. True, they are considered aircraft, which is why a lot of the rules initially for manned aircraft were applicable to unmanned aircraft. It wasn't a good fit. But the three kinds, the way they categorize unmanned aircraft in the FAA is very similar to in the manned aircraft world. We have public aircraft, which are your governmental aircraft. You have civil aircraft, which is really the focus on commercial aircraft. And then you have something called your modelist or your hobbyists, or recreational drones. The $30 one that Professor Oler may have bought at Radio Shack, the airport?
Airport.
You really did?
Yeah.
Okay, well, there's all kinds of new rules that apply to those now, so we're going to talk about that. Good luck with that. So, again, in the context of the 2018 FAA Reauthorization Act, they address all three, and what I will tell you is the focus of Congress right now is really getting those drones in the skies and opening the airspace to the national airspace to commercial users in particular. That is the emphasis here. So as you listen to some of the things that are in this act, and by the way, there's 47 sections. I'm not going to talk about all of them, but this is, I would say, groundbreaking legislation when it comes to drones. And what you're going to see, I think, in the next 5 years is going to be significant progress in this particular field. All right, so I'm not going to give you a history lesson here because there's a lot of history, really just between 2012 and the 2018 Act. But I'm going to talk about safety. And so there may be times where I go back in time to give a little bit of a context. And the first thing I'll do is, I believe it was 2017, the small UAS rule was published. And that was really the FAA's first crack, I'll say, at putting some rules out there to help commercial users. They're very restrictive. And there were a lot of comments about that. So, you know, there could only be daylight operations. It could not be over people. You know, the list went on and on and on. And so there was a lot of criticism when this rule came out. And so what you see now, and there are, of course, always waivers. You can always ask for a waiver. And the FAA had a Pathfinder program for beyond visual line of sight and to explore some of these other areas. But what you see now, what Congress is telling the FAA is we want to make sure that this is moving forward. And so they've given them specific timelines in this act. And so the first thing to be able, there's really 3 areas when we talk about safety. The first is registration and remote identification. This ties into security if you think about it, of course. And so what they've said is, first of all, they repealed the hobby exception, and we'll talk about that a little bit later. But they're actually establishing a framework for regulating those hobbyists, and the hobbyists and the one you just bought has to get registered. It has to have an ID. And so right now where the FAA is, and how many, I got law students here. Who knows a little bit about the Administrative Procedures Act? Anyone? Okay, I got, good, perfect. This rulemaking and all of the rulemaking in this arena is a perfect example of how the Administrative Procedures Act is supposed to work. And so what they've just done on February 13th, they put out what they call an RFI, or request for information, to the field for help us understand. Basically, it's a request to industry and to the public to submit information to the FAA to help the FAA understand what is the best way we can do remote identification. And so that's where they are in that process right now, but that just launched on February 13th, along with 2 other things I'm going to talk about. So registration and remote ID. Additionally, Congress has directed a 5-year pilot program to use whatever available remote identification systems already out there. And that will, so that's something they're going to be looking at. And also on February 13th, they did an interim final rule on external markings. So while they're moving forward with this remote ID concept, previously you could, the marking requirement could be internal to the aircraft. Anybody see a problem with that if you're law enforcement? First of all, of course, you can't see it, but even if it's on the ground, if I open that thing up, what could be in there? A bomb. Yeah, so the markings now have to be external, and they submitted an interim final rule on that. What does that mean? It's that they've asked for comments, and actually that goes live Monday. So while they're taking comments in, they went ahead and said, we're still going to go ahead and actually enforce this, starting this Monday. So very exciting, lots of things going on. Unmanned traffic management system is the next big area in the area of safety. Without UTM, that's what they call it, you cannot have commercial drones in the sky. And so lots of different rules on this, and NASA has been working with the FAA very closely for a number of years on this. But basically they said, the Congress said, continue your efforts. It must address beyond visual line of sight and remote ID and tracking technology and cybersecurity. Imagine that. Safety standards, et cetera. So they directed them to have a plan. But in the meantime, they said, while you're making a plan, we also want you to consider how we can start using this before the plan is final. I mean, that's Section 377. Don't believe me, read it yourself. Okay. And then the next thing they did, this is the third thing that just came out on February 13th. Again, this seems to be on a much faster track than what we have historically seen, is an advanced notice of public rulemaking for safe and secure operations of small UAS. And so what they're asking for here is an advance notice of rulemaking. They're seeking comment in advance of even drafting something for public comment about safe standoff distances, what should be the operational performance restrictions, unmanned traffic management, and I'm down to 2 minutes. Holy shnikes. Okay, expanded operations. They're doing a lot of really great things here. Flights over people. Yes, true. So that is another thing they just put out, a draft notice of public rulemaking of operations of small UAS over people. It's on the street. And by the way, all of this is on the FAA website. It's great bedtime reading. I highly recommend it. All right, privacy. I don't have a lot of time to talk right now because apparently I'm down to 1 minute, and I do want to re-attack later. Okay. So much in this area, but for those that are privacy advocates in the room, I will tell you, I'm down to no minutes?
Oh, no.
Okay, all right. She's making X's. I'm not really sure what's happening right now. For the first time ever, the FAA has owned the privacy issue. For years, they said, that's not our issue. It's safety and maybe a little security, but definitely safety. And this time they said privacy. In fact, they directed, this is amazing, for commercial operators, they said, you will have a policy that addresses collection, retention, dissemination, okay? And if someone in your company violates your own policy, that's going to be considered an unfair and deceptive unfair and deceptive practice, which is amazing. So this is very, I would say, earth-shattering for those in this arena that for years and years where the FAA has been saying privacy is not our issue. Okay, 2 seconds, and I know this is probably the cool stuff you want to hear about. Security. Counter UAS. So for the first time, the FAA has actually, the Congress has actually legislated on this topic. And they're actually deploying counter UAS systems to 5 different airports. Think Gatwick. Okay, I call these the Gatwick provisions. And one of them is going to be one of the top 10 busiest airports in the country. Now, they didn't say which one it was. I'm guessing Miami, but I'm not sure. And so that's super exciting. So there's so much to talk about in this arena. I'm sorry, I have like every one of these topics at least in our lecture, and I had 10 minutes. So I'm happy to talk to any of you at the break, and I'm really excited to answer your questions. So I'm out of time, apparently.
So if I crashed my drone, do I still need to register it?
Probably, yes. Before you fly it, you should register it, actually.
No, I crashed it.
Oh, well, throw it away then.
I flew it into a cow.
Self-defense.
Chased me for an hour. Thanks, Don. So the last person on our panel before we turn over to questions is Lieutenant Commander Tracy Reynolds from the United States Navy. One of the great things about Navy practice is that if you want to focus an ops law exclusively and in depth, it is a phenomenal way to do that. And Tracy's done that across her career, a lot of sea time. She's currently assigned to Carrier Strike Group 1 and Combined Task Force 30. And she's going to talk about the latest developments in the South China Sea for the legal arena, which I can tell you up in D.C. gets about as much attention as anything, especially on the DoD side. I will add, one of the things that they try and get us to do as members of individual services is get as much joint experience as we can. As you know, the services provide forces, and then we fight as a joint force so that we can leverage all we have. And to do her part, Tracy went above and beyond and married a Marine. So it's a good way to go. So Tracy, I'll hand it over to you.
Thank you very much for that kind introduction, and also thank you to General Dunlap for inviting me to be part of this wonderful panel. It's definitely an honor to be here. The South China Sea has strategic implications around the world, and it comes down essentially to food, fuel, communications, trade, and people. The South China Sea has over 3,000 different species of fish. 55% of global maritime fishing vessels operate there, and it constitutes about 12% of the global catch. 49% of the world's oil travels through the South China Sea, and it's estimated, depending on who you ask, either the United States or China, there's between 266 and 500 trillion cubic feet of natural gas in the continental shelf, and between 28 and 125 billion barrels of oil. 95% of international communications cables travel through the seabed of the South China Sea, and about 30% of global maritime trade, or approximately $5.3 trillion worth of goods, transit through the South China Sea. The shipping represents half of the globe's sea tonnage and a third of its total monetary value. There's 21 megacities, that's cities that have more than 10 million people, within 60 miles of the coast of the South China Sea. And there are territorial confrontations that have happened there starting back in the 1970s when we really started documenting them. There are multiple sovereign claims in the South China Sea. There's maritime features claimed by China, by Vietnam, by the Philippines, Taiwan, Malaysia, Brunei. It's 1.351 million square miles. And the sovereign claim established by China, the infamous 9 or 10- line, it contains about all of it. Now, Hong Kong is about 800 miles from the Spratly Islands, which is an area of contested maritime features in the South China Sea. And there is about 3,200 extra acres of land there that has been artificially constructed by China since 2013. Chinese Coast Guard vessels and fishing vessels navigate frequently throughout the South China Sea. China operates the largest fishing fleet in the world. It has about 200,000 vessels. The commercial industry there employs about 14 million people, which is 25% of the world's total. So hopefully that sets the stage for you on why the United States, from a national security perspective, cares about the South China Sea. And the United States military, as a force that implements foreign policy on behalf of the United States around the world, why we might be there. Now, I'm a lawyer. I'm active duty military. My client is the commander for Carrier Strike Group 1. We have an aircraft carrier, we have destroyers, we have airplanes, we have a whole lot of individual units that will operate wherever it is that we get told to go. And as the legal advisor for that commander, I want to ensure that military operations are based on law and policy. And there are a whole variety of sources of law to which we refer during the planning and execution process. But the general questions boil down to, first, what is our mission? Why are we going? And it could be a port call to Da Nang. We did one of those. It was the first one in Vietnam in 40 years. It could be a freedom of navigation operation where the United States formally shows our conscientious objection to any excessive maritime claims in the region. And China is often kind of phrased as the big bad. And I have to say, I was very sad that Sarah Michelle Gellar wasn't being Buffy in that particular film. But, you know, I'll let it go. But almost everyone in the South China Sea, coastal nation-wise, has some type of excessive claim, whether it's Vietnam or the Philippines or Indonesia. And from a United States policy perspective, we don't tolerate excessive maritime claims from anyone, even people that we have mutual defense treaties with, like the Philippines, or folks that we're trying to establish a better working relationship with, like Vietnam. So, what is our mission? Is it going to be modeling adherence to rules, laws, standards, norms? Is it presence operations, freedom of navigation? Is it our port call? What's our sources of law? Where are we trying to go? What are we trying to do? International law has a variety of sources. Some of it is customary international law, that is, actions nation states take out of a sense of legal obligation over time, custom. It's treaties, where nation states agree to act a certain way and sign a piece of paper promising that that's what they're going to do. Other sources, the treaties include the coal regs, how we're going to interact when we have any unplanned encounters at sea with a variety of naval vessels. So let's just pick a mission. So let's say that our mission is going to be traveling around Mischief Reef. Let's think about the law of the sea. The United States is not a signatory to the UN Convention on the Law of the Sea. We did sign it. It hasn't been ratified. The U.S. military, the Navy specifically, in the maritime environment, conceives of the UNCLOS as reflective of custom. So, Mischief Reef, what is that? What type of land is it? Well, it was nothing. Perhaps those of you who have followed the 2016 tribunal ruling that found essentially only rocks remain in the South China Sea. That has legal distinction because the type of land that you are dictates the navigational regime, the types of things that you can do and where you can go. Mischief Reef is a high tide elevation now because of land reclamation. So if we looked at UNCLOS, then the only navigational boundary would be 500 meters. That's what we do for oil platforms. So we'd be generous if we did that for Mischief Reef. But from a policy perspective, the United States Navy and the Department of Defense in general applies the concepts of the law of armed conflict throughout all military operations, no matter how they're characterized, national, international armed conflict, non-international armed conflict, all military operations all the time. So me, as a United States active duty military practitioner, considering not only UNCLOS provisions as they're reflected in custom, but also the law of armed conflict or the law of war, in all of my military operational planning, all of our treaty obligations, like how we're going to react if there's any type of unplanned encounter at sea among vessels, and any particular policy considerations as well, because just because I could drive my ship and dock at Mischief Reef under international law, tactically it would be a very stupid thing to do. But I'm choosing not to do it, not because it's unlawful, but because from a policy perspective, it's just not how the United States is going to interact in that region at this time. I have absolutely no idea how much time I've been talking because I have time for everyone else. Oh, look, only 4 minutes. It's exciting.
I got you.
Thank you so much.
You just took one of her minutes. You've got 5, so it's just...
She's entitled. It's okay. So what does all this mean in our mission planning to go to Mischief Reef? There are tactical considerations. Are there shoal waters? Am I going to land myself upon a reef if I try to drive my ship over there? Maybe, so perhaps I won't go because of those tactical considerations. But I want, as part of my presence operations, to show that there are international waters surrounding this feature and that I have the right under international law, both custom and treaty, to navigate there as long as I'm navigating with a due regard to other vessels that are navigating in that region, then I'm gonna go over there. But how far away from Mischief Reef am I going to get? Probably not within 12 nautical miles, because that would be indicative of a territorial sea. And you can only get in there if you have innocent passage or consent or force majeure, you're broken and you need to go and be somewhere safe. That's the only way that you're going to get within that 12 nautical mile region. So that's the law. But from the policy perspective, we're kind of okay with poking the panda a little bit, but we don't want to like cause this explosive bee's nest reaction where we have strategic implications for the actions that we're going to undertake. Now, from a law of armed conflict perspective, boy, we could talk about that for a very, very long time. But the principles that, for 2 minutes, but the principles that underpin our operational law planning and execution, we deal with them all the time no matter what. So what does that really mean for us? Well, one of the undergirding principles of the law of war is the principle of distinction. I'm going to make sure that my people that are fighting look different from my people who aren't fighting. So that way, when one of them pops up over the horizon, you don't just kill them. That distinction principle is inherent to me as an active duty military practitioner. Now, what happens when you have 200,000 Chinese fishing vessels operating around the South China Sea? What happens when you have Chinese Coast Guard vessels? Coast Guard vessels, from a U.S. perspective, are normally engaged in law enforcement missions. What is it that they're doing when they're in international waters outside of an artificially created reef? You know, what am I supposed to do? How am I supposed to train my trigger pullers when they are looking at what could be a perceived threat? Now, we're not at war. We're in phase 0. It's a peace type of process. You know, but how do I determine how I'm going to defend myself? Am I going to let someone get close enough to me that we're trading paint? Maybe. I mean, perhaps those of you who follow open source news and about the South China Sea see how much closer and closer and closer Chinese gray hulls get to ours. So there's that distinction problem. Are we watching the evolution of that distinction principle? Maybe. Now, there's a very interesting professor at the American University whose name is Professor Ken Anderson, and he warned about the obligation of reciprocity. The United States is always going to protect civilians all the time, no matter what, because Congress has told me that that's what I do, and also because I have a moral obligation to act that way. Now, obligation without reciprocity, according to Mr. Anderson, the breakdown of the rules of war even faster, where one side is pressed to protect the civilians of both sides put at risk, because that's how the other side deliberately wages war. I mean, after all, as the Nuremberg trial observed, the law is not static, but by continual adaptation follows the needs of a changing world. Well, what is changing in the South China Sea? Now, as an active duty military practitioner, I want to keep my people safe. I want to meet my mission. But I also want the United States to act in the South China Sea in a deliberate fashion so that we are not contributing to the evolution of law in a way that will negatively impact our national security interests, the lives of innocent civilians in the area, or the lives of our own citizens.
Great. So, yeah, time's up. If we're
Perfect.
We did it.
Turns out timing by committee really works. That's great. So let me open it up to questions. In keeping with General Dunlap's lead, start with the scholar, sir. Did you want to do that?
I'm here for oversight.
Uh-oh.
Yeah, I've been in this position before.
Yeah, let's have questions. Let's start with our scholar down here, and then we'll go to the gentleman in the back.
Hi, my name is Lethal Saki. I'm a 3L at Oklahoma City University. My question is for you, Colonel. With the FAA Reauthorization Act and the drones being so prevalent now, what kind of time frame do you see with line of sight? I know places like everyone's hot topic is Amazon, and they're going to be delivering tomorrow to my front door by drone. And what do we do about that? What's your opinion on time frame, since Congress has kind of pushed the FAA to move forward with this?
So there have been other timelines before that have been set and not met. I think the biggest issue for what you're talking about is going to be your sense and avoid. As you know, with manned aircraft, it's see and avoid, and I don't know that besides the remote ID, which I think is also critical, and UTM, those are your three biggest issues to actually have beyond visual line of sight and for the UAS to be prevalent in the national airspace. Until those three things are solved, it's not going to happen. And I mean, here you see some 5-year timelines. Like I said, I think other timelines have been set and not met, but there's definitely an emphasis on it, and I'm hopeful. And there's a lot of people looking at this. I think private industry has a vested interest in seeing this go forward, and obviously Congress is supporting that. So hopefully, you know, it's just the risk issues for safety. I mean, when you have incidents like Gatwick, and how do you handle that? You know, when you're shutting down an entire major airport for 3 days because you have someone interfering in your flying zone for the manned aircraft. I mean, those are the key things, and so that's why I said you really cannot separate the safety issues from the security issues. They are tied together, and so I would suggest that someone mentioned counter UAS. That's also going to be critical to this whole entire circle of life, I guess, to make it work. Yeah.
We have a question from before we get to the question in the back, we have a question from the overflow room, and it's for you, Kate. And the question basically is, what legal remedies and protections are available to foreign nationals who have not committed a crime and need to be removed from the country but cannot be sent to their home country because doing so may endanger their life?
So a broad immigration law question.
Very broad. I
And
think the answer is lots of them.
Yeah, there are a lot of remedies. There are remedies for people that are in court, in proceedings. You might have a valid removal charge, meaning you've overstayed your visa. That would be one example. But you could seek asylum, withholding under the Immigration and Nationality Act, cancellation of removal, adjustment of status, a waiver. I mean, there are a lot of, and protection under the Convention Against Torture. So there are a lot of different options, and if you receive one of those, then you're not getting removed.
Kate, I did have a question, a follow-up question. I think I've read that students overstaying their visa is a big issue, or is that, am I correct in that, or is that not, and how does that work?
Everybody overstaying a visa is a big issue. But yeah, I mean, we always think about the students because those were the 9/11 attackers, right? They came in on student visas. So visa overstays or visa violators are a significant population, and unfortunately a significant population that my team has to look at.
Okay, a question in the back?
I have a South China Sea question.
Yeah, if you could identify, I meant to say this before, if you could identify yourself and where you're from, that'll help us put.
My name is Yanni. I'm from the Duke University School of Nursing.
Excellent.
What are the legal and political options for the United States in the event China declared air defense identification zone over the South China Sea?
The U.S. Navy's policy in regards to air defense identification zones are that we only comply with them in the event that it doesn't negatively impact military operations, and that we're able to do so as part of safe navigation of flight. So if they do declare one, okay. Thank
Tracy,
you for
why don't you
telling us.
tell just a thumbnail of what an air defense identification zone is?
It's a geographic boundary that's determined by a nation state. And normally it's based on a variety of potential reasons, like national security, or because they're trying to control the airspace before you get to national airspace, which has like the same legal character as land. And so there is definitely a national security interest in any coastal nation to try to have good essay on who's trying to come in to your national airspace. So an air defense identification zone is simply that attempt to try to understand who's coming and why. Most aircraft that are trying to make entry into national airspace will have an established flight plan or will be operating off of the consent of the coastal nation that they're getting close to. Where it becomes problematic for active duty military practitioners is when, you know, we're just like hanging out. We're either operating in international airspace and just kind of going by, or, you know, we're getting close to the 12 nautical mile barrier and turning around, going about our business. And from the U.S. perspective, it's not legal under custom or treaty to require active duty military movements in an ADIZ type of zone in order to have access to that area. So from the U.S. perspective, the remedy is just like, thank you for telling us, and then go about our business. Under customary international law, if a state acts as if it has a legal obligation to do so over the course of time, that legal obligation can become one in fact. So from my perspective, and this is Tracy Reynolds' opinion, I've had a lot of conversations with active duty JAGs about this, and there are reasonable differences of opinion on how custom can develop. My personal opinion on this, having observed maritime navigation and aerial navigation in the South China Sea, is that the U.S. must be careful in acting in a way that could invariably give legal character to some of our actions that are actually tactical or operational. So I would want the United States, in trying to determine what to do about the ADIZ, to ensure that they're thinking through the long-term impacts on custom, as well as any actual legal obligations that are inherent to that ADIZ.
I think that's a great point. Just a little footnote is the U.S. kind of invented air defense identification zones during the Cold War for Russian aircraft that are approaching our shoreline. And Tracy's exactly, I'm 100% with you that we need to be very careful about custom that we develop, because it doesn't have a status under international law. People comply with it because guess what? If you're approaching this country, you don't comply with our ADIZ procedures, you don't get to land. And if you're a commercial entity, not being able to land in the United States probably is going to hurt your airline. On the other hand, if you see from time to time when Russian planes are intercepted by U.S. fighters, that's what they are doing. They aren't complying with ADIZ, and the same thing that we do, but we launch fighters when we see those Russian bombers who very routinely approach our shoreline. So it's a great question, and wow, fantastic answer. Another question. Let's go with the scholar here.
Shall we wait for the microphone, sir, or just go ahead and speak up?
It's right there.
You don't have to resort to, Steve, you don't have to resort to command voice yet.
Yes.
Go ahead.
Stephen Orango, University of Alabama School of Law. This question's for you, Ms. Briscoe. It's a two-part question. One, what do you think the national security implications are emanating from Venezuela at the moment? And two, do you think that America pays enough attention to the Latin American region as a whole in addressing the national security issues?
I'm glad it's
Those
not
are really light,
our
Ethan.
problem.
Thanks for the softball.
Yeah, real softball. Real softball.
Well, I think your question is veering more into a policy question than a legal question. We look for counterterrorism, national security individuals in kind of everywhere, just to make sure and try and keep everybody safe. What's going to happen in Venezuela, I really don't know. But I do know that there's a lot of interagency, U.S. government as a whole, attention being paid to our neighbors and what's going on in those countries.
The lady in the back there, I don't have my glasses on. I think I know who that is, but.
It's Danielle.
Yeah, okay, Danielle. You graduated Duke Law School?
Yes, I did. I'm a DoD attorney and a reserve judge advocate at U.S. Cyber Command. My question's for Zhanna. In the references you gave for the employment of cyber tools in, military operations, sabotage, espionage, traditional information operations, all of those are underpinned by robust legal regimes, right, that we've been dealing with as traditional military activities and clandestine and covert operations, forever. What utility do you see in analyzing cyber tools, effects, operations distinct from those traditional legal regimes under which we analyze, again, traditional military or covert and clandestine operations? Why is Talon useful if we already have an analysis of different types of operations being used in those more traditional military operations?
Thank you for your question. So if I understand it correctly, you're asking what is the value of accounting for the Talon Manual's articulation by Talon Manual 1.0 and also the more recent 2.0 in how the United States shapes its cyber operations strategy? Okay. Well, going back to what I had said at the beginning, in that we don't have a standard international legal definition, the Talon Manual offers one perspective talking about harm to humans, the loss of human life, and then we have harm to physical structures. Then you have another camp of the debate saying, no, we need to account for harm to data, and other theorists that had said, well, really, we shouldn't, the preoccupation shouldn't be there, it should be what misconduct should be stopped. I'm going back to that point to underscore that there's no one right view here and that we need an all-of-government approach and more input from various cyber stakeholders to have a breathable, flexible doctrine. In terms of how you should evaluate traditional military activities in this sphere, there is an excellent law review article that was recently put out by Bobby Chesney on Lawfare that I would highly recommend if you haven't already seen it, looking at how the concept of Defend Forward and the DoD's 2018 Cyber Strategy Report can factor into that. But thank you for your question, Danielle.
Just so everybody understands, the Talon Manual was put out, it was funded by NATO. It is not a NATO document, and no country officially embraces it, but it's a treatise out there that is considered authoritative. And interestingly enough, there is a chapter in the DoD Law of War Manual that came out in 2015 on cyber operations. It's the first time that there's really anything, because up until not too long ago, you could not even mention cyber in the military. And the DoD Law of War Manual has no reference to the Talon Manual, to my knowledge anyway. So I think what Zhanna is talking about is we are in an evolutionary phase. And something that Tracy mentioned is one of my favorite quotes about the law of war and how it develops. And it's an international law, especially customary international law. It's not written down definitively like we think of a treaty, but practice can be very influential on how it develops. So that's what, and interestingly enough, and Zhanna, you need to slap me down if I get this wrong, but I think that the most recent look at China and Russia is they're not so sure that they agree that the law of war even applies to cyber. Did I get them?
That's correct.
Blind squirrel finds it. Gentleman in the middle there with the yellow shirt and.
So my name is John Kokwich. I'm a retired naval officer. I'd like to ask a Navy question to the commander regarding South China Sea. So you talked a little bit about freedom of navigation operations, and it's my understanding within the last month or two, we did conduct a freedom of navigation operation in the South China Sea that upset the Chinese, as you would expect. My question is, can you talk a little bit about how we decide to execute those rights? Is it done by the Carrier Strike Group Commander? Is it done by the 7th Fleet? Is it done by the Pacific Command in Hawaii? Can you talk about the strategy that goes into that? Thank you.
Thank you for your question, sir. Freedom of navigation is a bit of a term of art. There is a freedom of navigation program where different geographic locations are identified as ones in which the Navy will operate so that the United States can register publicly in an international forum that we do not perceive that as being an appropriate maritime claim. And some of the things that you're talking about, like I'm thinking specifically of the Decatur. That happened in 2018. I think it was like the October timeframe, if I remember correctly. So in instances such as that, then it's part of a quarterly program where there is extensive documentation of the nature of the event. And then on an annual basis, there is a document released that's easily Googleable that articulates all of the places in the world where the United States Navy has operated as a way to publicly recognize the fact that that is an excessive maritime claim under both custom and the UN Convention on the Law of the Sea. Those decisions are made way above 7th Fleet. I mean, it's almost like a, and this is again Tracy Reynolds' opinion, it appears to be kind of an interagency discussion where the federal government is in talks with other branches to ensure that the appropriate message is given. I've heard the interagency described as kind of a bag of octopuses in the sense that you have all these little tentacles like stuck all over everyone, and that's the manner of communication as opposed to a nice, neat hierarchy, which as active military I prefer. But those types of conversations are what generate the specific geographic location where a freedom of navigation operation will take place. But we often say freedom of navigation when what we really mean is adherence to laws, rules, standards, and norms in the maritime environment. So the Navy will say FON or freedom of navigation, well, what we really mean is operating with due regard in international waters.
What's interesting about what Tracy says, you can go online and the publicly disclosable document is there, and you'll see these operations are not just conducted about China, they're conducted about even some allies. And interestingly enough, sometimes that's the first time the country finds out that they've been subject to a freedom of navigation operation. But it's basically some country decides that they're going to make their own rules for the international environment, and the United States says, nope, it's not going to work that way, and we're going to sail our ship exactly where you say is we can't, because we don't want that to be established as a custom. Let's have another scholar right in the middle here.
I wanted to know if you think that there are other geographies that are susceptible to the kind of territorial claims or land reclamation actions like the South China Sea, or if that geography, both political and physical, is unique. I was thinking of the Arctic or the Persian Gulf, but I don't know.
Thank you very much for your question. My perspective is that it's applicable in every domain that there is. I think what's happening in the South China Sea could be indicative of the Chinese and the Russian response in every area where they will exercise force and try to ensure that their foreign policy perspectives are respected. So, forgive me for taking just 1 second here, but we know in 2016 the UNCLOS Tribunal found that there was no legal basis for Chinese claims in the South China Sea. I think it would be foolish to think that Russia is not carefully watching that in terms of their claims in the Arctic for that, and I'm going to butcher the name, everyone knows what I'm talking about, right? There's the gigantic ridges on the Arctic subfloor where there's a variety of nations, whether they're Arctic nations or not, say belong to them. And so I think that we, as kind of academics in the sense that we're always learning, have to be aware of those things, particularly if the clients that we're advising will be implementing what could be perceived as U.S. perspectives on those particular principles. And outer space is the same. That is a domain quite similar to the maritime one, where it could be conceived of as a common area, where nation states will be acting both in their capacity as a nation state, but also where we have a lot of private citizen activity as well. So from a custom perspective, there's some concepts within space law that talk about how civilian activity in space is indicative of state practice. Well, you have Chinese satellites, you have Russian satellites, you have Elon Musk's car with the astronaut like floating around, right? I mean, there's a whole lot happening there. And I think that while analogies can sometimes be dangerous, that they're also very useful when you're trying to predict how a nation state will act in a different either maritime domain in the world or a different domain of war at all, cyberspace. I mean, that's also been conceived of by some scholars as a common area Well, what principles of law are we going to apply there? What's the foundational law? I mean, I'm a maritime attorney, Yay Sea Services, so when I see things like cyber or space, I'm thinking in terms of, what customary international law principles can I apply there that have a similar character? And we have to think about that in terms of the Arctic, in terms of outer space, in terms of cyber, and also other geographic maritime areas as well.
An example I'll just throw out there, it's a great question in terms of choosing to engage in a career in national security law. So any of us that have been senior folks stationed over in the Persian Gulf, every time we sail a carrier through the Strait of Hormuz, the laws are very, very technical, but well established in terms of what we're allowed to do, what can loiter or not loiter as you're going through, how quickly you go through. But as a judge advocate, it's a standard experience that you will be standing next to the 3 or 4 star while she or he is watching the carrier move on videotape to make sure that we're abiding by all of the requirements. And then when the Iranians start running speedboats within range and they're turning to you and saying, okay, at what point can we engage? And then you're getting ROE, rules of engagement decisions. It's as real as it gets. It's very real. And so these examples that Tracy and the others have just given, this isn't hypothetical. It's not academic. It is applied and it's very real.
Transit passage in an international strait, I stand next to the admiral on the bridge during the transit.
Yep.
Innocent passage from one area of international waters through territorial waters that are recognized under either custom or unclass, I stand next to the admiral on the bridge as the strike group goes through. If it's one of my destroyers, then I'm standing next to the admiral, probably in our tactical command floor, because the carrier is going to be someplace else other than where the destroyer is. But we're watching on screens to make sure the entry point of the destroyer going through that maritime demarcation and back. I mean, it's very much as tactical as law gets. Do I have the legal authority to be where I am? How am I supposed to act in this particular domain based on where I am? What are the policy implications of the choices that I make where I am? Tactically, is what I'm doing okay for my operators to keep them safe and healthy? Those are all those considerations.
With huge strategic implications.
Yes.
Gentleman right there.
My name is Richard Ellman. I'm a retired Durham resident. What are the prohibitions on, if any, for the United States or any other country to drop humanitarian supplies in countries that are war-torn or are experiencing starvation?
I'm going to assume that that's a question for me, sir. Is that accurate?
Whoever may know the answer.
Prohibitions.
Yeah, so I can.
Let Adam take a swing at that.
That's another great question.
Tracy's not on the front page of the Wall Street Journal.
Although she's wearing the same thing in her photo too, I'll point out. So
I don't have to make any of those dressing decisions.
just wait. In international law, this is one of the great questions that's out there. Basically, you have Nuremberg, where there's, for the first time, this idea that you can piece sovereignty, right? This idea of sovereignty, that you cannot do anything in another country unless you've been invited in, it's self-defense, or since 1945, the UN Security Council says that you can do it. That's generally, those are generally the 3 reasons. I mean, the reason that the Russians are operating openly in Syria is because Assad invited them in. The reason that they're operating with little green men in the Ukraine is they have no legal basis for being there. Is a big part of it. The question of humanitarian aid and when can you, without invitation, a UN Security Council resolution or being invited in, go into another country to drop aid really is a post-Cold War discussion that picks up around 1995, largely in the war crimes scenario and going after war criminals. But the problem is the actions got a little bit ahead, or I would argue the actions got a little bit ahead of the law in it. And so we have this concept called responsibility to protect, which is the basis that a lot of countries use in order to go in. So if a country can't take care of or is unwilling to take care of its own people, can the international community go in and help that country or give aid, supplies, or whatever? And so in 2005, in one of the largest international conferences ever, the world basically got together and said, yes, you can, provided there's a UN Security Council resolution. And in 2011, UN Security Council Resolution 1973 let us do that. The Russians and the Chinese said, okay, we're not going to hold off on this. It fits the R2P requirement. Go stop the looming genocide in Benghazi. And as we know, by October, that turned into regime change, which is exactly what the Russians and the Chinese were scared would happen with intervention in the first place. So legally, if somebody comes up to me and says, you know, Adam, can we start dropping supplies in for humanitarian relief, and you don't have one of those three key bases, you're taking a real risk with it. Now, there's you know, safety of life, et cetera, other exceptions along those lines, but it's complex, and I would suggest post-Libya, it's harder to do now than it was 7 years ago, 8 years ago.
The classic, what happened now is Venezuela, where we're taking food supplies and leaving it at the border of Venezuela.
Yeah, we don't have a UN Security Council resolution.
Haven't been invited, and it's not self-defense.
Dawn, let me ask probably kind of a technical question. How viable, do you see industry moving in the direction where we are going to have counter-drone technology available, you know, even commercially? And is anything being talked about would permit, say, a private company that doesn't want their area overflown, perhaps for proprietary reasons, is there going to be any capability, or how do you think that's going to go?
Okay, that was another softball. That's a tough one because I think now you're kind of private companies would now be almost vigilant. You know, it'd be vigilantism. You know, encroaching on law enforcement requirements. So I don't, unless there's some agreement with the government to permit them to do that, or they're designated as critical infrastructure, I don't know that you would see that happening. And I think that would actually be a dangerous thing too. You know, you've got your private Joe citizen in his backyard, and you know, Johnny flies his drone over and he's using his counter UAS technology to take that thing down. So I just feel like that would be a big encroachment on law enforcement activity, and I don't know that I would see that happening.
What about the scenario where somebody flies a drone right up in front of somebody's apartment window and just stays there?
So that's something I didn't get a chance to talk about, but in the FAA Act, and a number of states actually have criminalized specific behavior with drones. So they either made it a criminal enhancer, you know, if you, for example, conduct voyeurism, but you use a drone, it's enhanced penalties, et cetera. They've just created a crime in 18 United States Code in this last FAA Authorization Act, where if you're flying through a public building, that it would be a crime, or you're going near the vice president's house. I mean, they list out specific residences that would be a crime under 18 U.S. Code. So states are involved in that, and now at the federal level as well, of creating drone crimes, I'll call it.
Zhanna, I can't help myself, but that stimulated another question. Give us a minute and a half till we get back to our audience questions on hackback and where we are with that. In other words, if a company is attacked, you know, what can they do? Can they try to go after the perpetrator or the perpetrator's equipment?
Technically, under the law, no.
Zhanna.
Oh, okay. For a drone or for a computer?
Well, we just...
Because there's computers on drones.
Yeah.
It's all relative.
Keep my mouth shut, you know, I don't...
Thank you. Thank you for the jumping off point. It depends on the nature of the attack. If, for example, if it was an espionage operation, I know that the FBI has a special department that is designed to take complaints from the private sector if they think that their sensitive trade information has been compromised, that they can strategize with the government on the next steps going forward. So that's the best answer that I can give, that the government is trying to catch up, to extend that hand to private industry, that the resources are out there.
Yeah, it's generally illegal unless you are working with the government. Ryan? Is this from you or from Dell?
It's from Dell.
Mm-hmm.
So General Dunlap's constantly referring to the service dog you've seen walking around. That is Dell, in case you didn't know. My name is Brian Foltz. I'm from the University of Miami, 3L School of Law. My question is for Dawn. With this idea of domestic drones, it causes me to ask, what are the policing, well, more government use of drones, and the Fourth Amendment issues that can be applied when you have police forces or government entities flying drones down the street for, visual purposes. What Fourth Amendment issues does the FAA address?
So the FAA is not addressing that at the state level, and that was somewhere in my 19 pages of notes here that I didn't really get to. But from really 2013, what you saw was this explosion of state drone legislation. And so right now, every single state in the United States has some kind of drone law on their books. The majority of those laws actually address privacy and the Fourth Amendment, and the majority of them that address that issue, and law enforcement in particular, prohibit the collection of information, the collection or acquisition of information with a drone, unless there's an exception that applies. Now, the interesting thing is they don't always apply all of the exceptions you would think of under the Fourth Amendment jurisprudence that are well settled in the law. So, for example, there could be a state where if the individual consents, it's actually not permitted in the law for the law enforcement to collect that because it's not in their law. And so the states have definitely moved out on that, and those have been on the books for years. I haven't seen a ton of litigation in that area, people challenging those from a preemption or other issue, because law enforcement powers are clearly within the realm of the state. And so, yes. And there's some great websites, by the way, besides FAA, no federal endorsement. But Jonathan Ruprecht is an attorney down in Florida, actually, and he has an amazing website. He actually has a map of the United States. You click on the state, and it pulls up all the drone laws that apply. And there's other apps and everything, other things out there. The FAA has a Before You Fly website as well.
Gary?
J.J. Mahoney. I'm with the Department of Housing and Urban Development. My question is for Colonel Zoldi. The technology that's enabled drones to grow so rapidly is equally applicable to other things. And I'm wondering if these specifically are covered by the pending legislation. And probably Professor Oler is wondering too, because he may want to buy one. But specifically lighter than aircraft and radio controlled or other remotely piloted model aircraft, are they covered?
So the answer is yes. In this particular reauthorization act, the Congress repealed provisions in the 2012 FAA Modernization and Reform Act, which was some of those provisions in that 2012 act had been interpreted as prohibiting the FAA from regulating modelists and hobbyists. That was outright repealed just recently. And so now what you're seeing, and what I was kind of alluding to Professor Oler over here, was if you buy one of these hobby drones now, you actually have to take a knowledge test. You have to register it. So yes, and again, it's the safety and the security are tied so closely together here. This is why they're doing it. Again, I called it the Gatwick provisions, but that's exactly why, because people, I have a mentor that calls this the democratization of aviation. Because what you have now with drones, something you can buy in the airport for $30, is the power that was typically reserved to a nation state. And so it's not really a toy anymore. And people have come to appreciate that, and Congress has. And that's why you're seeing these laws being enacted.
Let me throw something out to the...
It definitely applies to the model aircraft. The provisions on the unmanned aircraft systems do not address the lighter than aircraft.
Let me throw...
Unless, are they manned? They're manned. They're not manned. Then if they fall within the definition, I'm sorry, sir, of unmanned, then they would apply.
Let me throw a related question out to anybody on the panel. What about the Internet of Things? Don made the point that, there's a computer in a drone and there's a computer in your refrigerator. What should I be concerned about my refrigerator attacking me?
No, but you should be concerned that it's recording you. Or other people are watching you in your house.
Yeah, talk a little bit about that. Do you see legislation moving forward in that way? Because the problem with the Internet of Things, as I understand it, is all these devices are linked to the web, but they weren't built with any encryption. So, and it's not likely that you can retrofit them with encryption. So any response from anybody on the panel about this?
Sure, I'll take the first crack, passing it down. So yes, when you have these devices now hooked up to the internet, the attack surface is widening as well. So there are more vulnerabilities. However, the private sector is trying to catch up to patch those, but it's a continual battle to catch up with that. There was a very good article in Consumer Reports that may have actually been titled, "Is My Refrigerator Going to Attack Me?" or something to that effect. But it talks about what you can do as a consumer to protect your privacy in your home if you are bringing in these smart technologies into your home. There, if I recall the article correctly, they were talking about a smart coffee pot and how if a hacker was able to gain access into your coffee pot system, they could find out how often you would run it and then determine, the owner hasn't run this in a couple of days, maybe they're not home, and potentially that could fuel a burglary operation. So it's incredible the ways in which this technology can be exploited, regular household devices.
Beyond how caffeinated.
I'm sorry.
Beyond how caffeinated you are, they actually recognize whether you're home.
Take one more question from the audience, and then I'm going to ask our panelists, because we have a lot of students here, what would they recommend that students be doing, studying, courses, whatever, if they're interested in this very dynamic area of the law? But the gentleman in the red.
My name is Joe, and I'm a panelist on a political talk show. A drone question. The conflict between Second Amendment rights and zones that are small arms.
So that was actually just legislated as well in the 2018 Act, where the Congress has forbidden use of dangerous weapons from a drone. So they've spoken on that issue. I don't know that it's been challenged yet. I imagine it will be, and we'll go from there. But so it's in the most recent FAA Reauthorization Act.
Somebody have a really short question?
In a scenario where you have a cyber attack that have kinetic consequences, what is the level of evidence that's acceptable if litigated, short of showing classified sources and methods?
Wow, that is a Herculean question to answer in 1 minute, General Dunlap.
1 minute.
I didn't fit the criteria there, just so everybody knows for the future.
I'm happy to circle back with you later, sir, on that to give you, I will answer it. I'll do my best in a minute. I actually developed a diagram. I use the analogy of a piano keyboard to help visually explain the range of state conduct for states in cyberspace. And if you play the piano, sir, middle C is often the traditional starting position when you're first learning how to play a song. And here, using that concept, your starting position is the United Nations Charter, looking at Article 2, Sub 4, and what is a use of force, and also Article 51, defining what is an armed attack. From there, it goes out showing the range of permissible state action. There's no precise formula for measuring a use of force in cyberspace. However, the common approach has been to examine the scale and effects of our operation to see if it does rise to the level of being an armed attack. This diagram imparts more clarity, and I'm happy to share with you a copy later, but in 1 minute, that's the best I can do, sir.
That's very good.
You did great.
Good.
You did great. And you can see, I really looked hard to get the very brightest minds in these different areas, and it's wonderful. Let's hear, Adam, starting with you, and we'll just go right down the row here, just real quick, some advice for lawyers or budding lawyers, and also for our many people in the audience who are kind of interested in this field. What would you tell them?
The biggest thing that we're wrestling with up at the Joint Staff and at NDU, I'm an extension of the Joint Staff, is how to leverage and manage informational operations. The utility of the military instrument has been drastically changed because of the ability of our enemies to wield imagery in order to scare, shape other opinions. The traditional news journalist gatekeepers they're still there, but they're not the gatekeepers anymore. And legally, how are we going to keep up with that domestically, but also internationally? You can look at the Gaza war from 2014 as the perfect example. IDF is never going to defeat, or Hamas will never defeat the IDF on the battlefield, but if they can strip Israel of its legitimacy and get the BDS movement going, they can force them to the table that way. That's not been true before, and there are enormous legal implications in the role for future lawyers in trying to discern how the law is going to play into that.
Tracy?
I encourage students to read and consume media broadly. A foundation in the classics, I think, is quite useful in order to train your brain to pick out the analogies that are appropriate to help you see issues across a broad range of domains. Mencius is a Confucian disciple who talks about a farmer who destroyed his corn crop because in his efforts to make it perfect and wonderful, he pulled on it from the top to make it grow taller. You can apply that to the South China Sea as the distinction between the Westphalian concepts that the West applies in military operations and strategic thought. But if you aren't versed in these types of stories or strategic discussions that happen at the classic level, it may be quite foreign to you. So don't disregard Battlestar Galactica or Star Trek or these types of storytelling techniques, because everything from Plato all the way through what are a Ghost Fleet are a great way to broaden your issue spotting brain.
I don't know that I'm the poster child for liberal arts education, but I buy into that wholeheartedly. University of Scranton right here,
We went to the
history and
same
philosophy
law school.
major. So I totally agree. Classics are important, critical thinking, but I would say on a kind of similar but different note, crack open the books. Pretty obvious, but how I learned what I know about drones or unmanned aircraft, I read everything I could get my hands on. Go to conferences like this, and 2-second public service announcement, not endorsed by Duke or the federal government. If you're interested in drone law, there is this thing called the International Conference on UAS. They're going to hold it in Atlanta, Georgia on 12 June. Registration goes live. You can Google it, ICUAS 19. So there's a one-day CLE legal track, and you're going to hear from amazing people like General Dunlap, who's going to be giving a keynote at that event. So read and get out there going to these conferences and just learn all you can. Just eat it up.
Yeah, and we do endorse it.
You endorse it. I can't.
Kate?
I guess I have some similar observations. I thought one of the most important things that I took from law school when I went into private practice and now the government is kind of classes like First Amendment, federal jurisdiction, ones where, you're really screwing up your head to be like, what is going on here? And what does this case law mean? And I draw that in contrast to some cases which are more like, I never had to take uniform commercial code because for some reason that wasn't on the bar my year. And I was like, woohoo. But things that are a little more structured. So take the brain teasers. It's the same reason that we say study the classics, because you're going to be looking for patterns and trends and what's missing here. And is this like that environmental law, con law case? Is there a similar principle that I could apply in this other field, right? So it's the connections and the creative thinking. So I really encourage you to challenge yourselves as much as possible, particularly in law school, which is a wonderful learning environment to bounce ideas off of people and get creative, because that's going to make you a great lawyer as opposed to a good lawyer. Writing and advocacy, if you can't express your views, you might as well not have them. So you got to be able to express it well. And for the national security world, I would say one of the future areas, not future because we are steeped in it now, but First Amendment. What's the balance? There are a lot of people saying a lot of horrible things online. How do we differentiate who the person is who needs special attention? And how can you do that consistent with First Amendment protections? So that's the line we're trying to walk, is balancing those two interests. So bone up on your First Amendment law.
After they take my national security law class. Right,
right, obviously.
Zhanna, you got 15 seconds.
I echo Professor Stanbury's recommendation yesterday from the Lens talk, the point being that people often will forget what you say, but they'll remember how you made them feel. So when you are networking in this space and you're developing your brand, be mindful of your interactions with others. And if you had a wonderful mentor, pay it forward and be a mentor to someone younger than you who's interested in your space. Thank you.
I guess that's some kind of warning, but I want to thank the panel. It much exceeded my very high expectations. And as you can see, I know people are going to be saying, Charlie, you should have had twice the amount of time. Well, here's the good news. I think most of our panelists are going to be around for the rest of the conference, so catch them on the break, which is now 2.5 minutes shorter. Otherwise, so now you need to go out and pick up your box lunch, get back in here. We have a, no kidding, working lunch.
That was really interesting.
What's that?
Your work, it just sounds really